And now, broadcasting from Titletown, USA, here's Joe Simon.
Are you a small business owner? Are you a closely held business owner? Are you a business owner or partner? I've got something to talk about with you today. It's buy sell agreements, which tie nicely into your business succession plan. What? You don't have a business succession plan or a buy sell agreement? Stay tuned. That's what we're talking about today. The buy sell agreement is really the glue that holds the corporation together. It's sort of the legal mission statement or mission plan for when bad things happen or when things that you plan for happen. It's a good, bad, and ugly type of document, possibly. It's been around for a long time and it's been in the news back in August, September of 2024, and continues to grow and evolve. Things have changed a little bit along the way, but from an insurance advisor perspective, that's what we're looking at today is your buy-sell agreement and how to have guaranteed cash when you need it. And we'll get into that today. So buckle up. Here we go. We're talking about the buy-sell agreement. You know, there's two different types of buy-sell agreements. There's the cross-purchase buy-sell agreement, and then there's the entity purchase buy sell agreement. We'll talk about both of those as we get into this today. We'll try to make this short and sweet and sort of simple. But I have to say, as we get started, this is definitely a conversation that you must have with your legal counsel, your attorney, in particular, attorney that knows about and practices in the area of business succession planning and buy sell agreements. Well, what happens if you're a sole owner of a business? It's a corporation, but you're the only owner of the corporation. Well, then there's a buy sell plan that could be called a solo buy sell plan, at which time it could also involve an insurance policy that takes care of the buyout needs and exits that need to take place and the obligations that take place. But really, the best place to start on this conversation is what we'll talk about today as the 4Ds, and that's death, disability, departure, and divorce. All of those things can happen in a business owner or a partner's lifetime involved with the business. Perhaps this is you. Perhaps you know somebody that's walked through that. And it's important to talk about that. And then once you sort of have a plan to get the sort of out of it and have a plan that's legally recognized, and that's your buy sell agreement. What we're going to focus on today is number one, taking that time to have that discussion with your attorney. And then at some point, maybe in the beginning, you bring in your insurance advisor and they begin to talk numbers with you as to what you feel the value of your corporation is and how that would stand up amongst its peers and amongst a serious buyer. A $10 million business should be noted as a $10 million business, not a 15 or $17 million business. This will come back into the conversation when we talk to underwriters about the proper value of the life insurance and how to justify that. It often helps to have a statement, formal statement from your CPA, possibly your attorney as well, as your qualified insurance advisor takes that message and that case for you to have the best and the proper amount of life insurance in place. Let's talk about that. So we have this cross purchase buy sell agreement. Perhaps there's myself and one partner, and the business is valued at $10 million. And we could pretty much substantiate that without a doubt. We each own 50% of the corporation. So we get life insurance on our lives for the value of our ownership in that corporation. In the cross purchase agreement, we would each own the policy on each other. We would also be the payer and the beneficiary. So at the death of one of those partners, let's say it's my death, my partner would receive the death benefit that they've paid for and claimed to be the owner of from the beginning and the beneficiary of. And that dollar amount is used to buy out the stock from my estate, from my family, from my widow, and vice versa. Typically in the buy-sell agreement, there's a period of time that's written in there that this all must take place without a doubt. In the event of a disability, uh, very similar. The only difference is I didn't die. I have a disability that's been determined by a qualified medical professional, and the qualified medical professionals at the insurance company that's insuring me and the value of my shares in the business. Typically, 65 to 70% is the maximum we can insure that for. And typically, there's a 1 or possibly as much as a 2-year waiting period where it's without a doubt proven that Joe, is not coming back, and the partner wants to move on with things as he or she should. The beauty in this is what I call the missing page. What we often find is the language as to what the dollar amount of the shares and the time frame in which this all should take place is in the buy-sell agreement in language, but there's no guarantee of the money being there because there's a missing policy. The guarantee from the insurance carrier that's insuring my life that will make that lump sum or possibly a 1 or 2-year buyout, a phase out amount, and all written in the buy-sell agreement how that should take place. The missing page is the story of the buy-sell agreement being in place, all the homework being done, but they forgot to kind of seal the deal by ensuring the members of the ownership we're talking about here. So there's no real guarantee that the money will be there at possibly the most crucial time in the corporation's life. The entity purchase is something that's a little bit different. That's one of the second two buy-sell agreements. This is where the entity, the corporation, is the payer of the policies, is the owner of the policies, and is the beneficiary of those policies. So think of the hypothetical situations we've just talked about. Joe dies. Well, in this case, death benefit is paid to the corporation. Corporation buys Joe's family out and brings in those shares into the corporation and holds on to those until a new or an existing shareholder buys those portions back or out. Same holds true with the disability buyout. Joe's disabled after a certain period of time. It's determined he's not coming back. The buy-sell agreement is triggered to begin that disability buyout. The dollars from the insurance company go to the entity. The entity buys out Joe's family, retains those shares, and sits on those shares until a future buyer, could be an existing shareholder or an incoming new shareholder, buys those shares from the corporation. So the cross purchase and the entity purchase buy-sell agreement. Two important things as we look at how to insure ourselves and our buy-sell agreement. For more questions on how something like this should play into your succession plan and buy-sell planning, what type of life insurance, how to place it, how to get that disability insurance, who some of the best carriers with the best experience are, and how to prepare for the underwriting in this. These are all questions we address when we do that business succession planning and that buy-sell planning. So until further notice, have a prosperous day. Feel free to email me any of your questions to jsimon@davinciinsurance.com.
You've been listening to the Joe Simon Podcast. Big ideas with powerful stories and real-time solutions. Business succession planning, executive benefits, employee benefits, tax beneficial savings, and more. Remember, information discussed here today is dated and not specific to your situation. Always seek personal counsel from qualified advisors. For more about Joe Simon, go to davinciinsurance.com. Joe Simon is a licensed insurance agent in the state of Wisconsin. Licensed to advise on accident and health, life insurance, disability insurance and annuities, as well as qualified long-term care insurance. Make sure to visit the DaVinciInsurance.com archives for more of our podcasts.